Now let's turn back to California, where closing arguments continue in the felony assault trial for A$AP Rocky. The rapper is facing up to 24 years in prison if he's convicted of firing a gun at his former friend Terrell Efron following a heated altercation back in 2021. We want to take you back into court. We are still hearing from the defense attorney give his closing argument to the jury, and everything seems to be going along normally until it starts to get testy. Let's watch.
Obviously, Rocky knew that was false and was shocked because that really didn't make a claim, so which is why Rocky wrote back, I tried to lie. The fact that during this trial, Rocky didn't mention in his message anything about his prop gun. They don't consider one thing, though, about that. They don't consider one thing. Unlike Relly, Rocky didn't have a reason at the time he sent that message about stop making shit up. He didn't have a reason at the time, or think he needed a reason, to create a record of events for some later date. At the time he sent those messages, Rocky thought they were between the two of them. And he knew why Relly understood his claim wasn't true, because it wasn't true. Rocky didn't shoot him and was aware that Relly knew he didn't shoot him because a prop gun doesn't shoot bullets. A Star pistol doesn't shoot bullets.
Tacopina.
Yes, sir.
Stop.
Okay.
You want to finish the thought?
If I could, just a thought.
Finish the thought, and then we'll take a break.
This is the perfect place to break. And that's why after learning soon thereafter that Relly was contacting his manager trying to extort money from him, Rocky was done communicating with Relly. He stopped answering completely and said, go to the police. And what kind of person tells someone to go to the police if they know they've committed a crime? I could resume from here and come back.
All right, we'll take a break until 11 o'clock, folks. Please don't discuss the case amongst yourselves or anybody else. And we'll see you in 15 minutes.
Not exactly sure yet what is happening. The jury is being sent out. It's unusual during closing arguments, number one, for there to be objections unless it's something egregious, and number two, for a jury to be sent out like this during closing arguments. But certainly we're going to wait and see what the judge has to say, what the reason is, and how the attorneys for each side handle it. Let's see if we're ready to go back in. If not, I will bring in Bob Bianchi. Bob, hang on, Bob, stand by. I understand that we can go back into court.
Unequivocally, do not mention the prosecution's perjury. Here's a quote. On an objection, you overrule. The prosecution accepts their witness committing perjury. It's improper, it's unethical, you said you're not going to tolerate it, and I object, and you make it clear to the jury that my objection you find annoying. It's very clear that the tone that we get when we make an objection that should be sustained is, what are you doing? That's what was said. You specifically...
Lower your voice and don't yell at me. I told you before. I'll listen to what you say. Speak in a normal tone of voice.
Judge, we're doing the best we can to make sure that this trial is ethically conducted. They have repeated, I've objected, you told them it's improper. You overruled repeated objections where they are saying improper things. He just said a moment ago, this is a direct quote, the prosecution accepts their witness committing perjury. I object. You respond, that's appropriate comment on the evidence. It is not appropriate comment on the evidence, Your Honor. I don't know if you didn't hear it.
I didn't hear that.
So, Judge,
what I heard, I could have been wrong, what I heard was that Mr. Tacopina was describing Relly as committing perjury.
Judge, that's a direct quote. The direct quote was, the prosecution accepts their witness committing perjury. Here's another one. Relly committed extortion. There is no legal...
Do you think the jury's going to ask for what the legal description of extortion is?
Your Honor.
Forcing someone to pay money, that is, quote, extortion.
No, Your Honor.
Go on to something else.
I want to make my record. I mean, you're going to do what you're going to do, but I have a right to make my record. No lawyer can get up here. No lawyer can get up here and tell the jury that a crime has been committed when there is no instruction on that crime, when in fact, Your Honor, that's not the legal definition of extortion. We've objected, and the court, again, is basically telling me, don't worry about it, it doesn't matter. Your Honor, it does matter. After a while, when there are so many of these things, they add up. And when the court is saying, well, What do they care about it?
No, I didn't say they don't care about it.
It's improper argument. And the problem is...
I don't agree with you. I think using the word, quote, extortion to describe the conduct is not improper. I think it's fair comment on the evidence. You, in your rebuttal argument, you can say it wasn't extortion.
Your
You
Honor,
can address it.
Your Honor, the bigger issue, as I said, is the court was repeatedly told do not connect the prosecution to committing crime.
I'll tell you what, I didn't hear that. I'm going to ask Kathy for the exact quote. If that's what was said, I'm going to sustain your objection, and I will apologize for overruling.
Judge, I respond, please, on that one issue. Not everything else he said. What I said was, and I agree with what I said, but understand the context of it, okay? I didn't say this is more perfect. I didn't say it yesterday, I didn't say it today. But one thing I said, and it was fair to comment, was the prosecution accepts their witness committed perjury. And what I mean by that is in regards to one thing, and it's indisputable, Your Honor. It was regarding Relly saying the tape was fake. The tape was fake. They got up, cross-examined Mr. Sajemi, did not ask him if the tape was fake or not. Okay? They then put up transcripts of that tape recording with attributions to Mr. Efron. So that means just by that very fact, they accept the fact that he committed perjury. I'm not saying they support it, but they accept that witness committed perjury. They have to. Let me finish. There's no other way for them to move forward unless they say that wasn't perjury, but it was because he said that was fake. We know it wasn't fake. It was real. That was perjury. So by then moving forward with it, arguing that the tape is important for the prosecution, that Efron said these things, that when they cross-examined Sajemi, that wasn't being a good friend to Efron because he made a tape. All that is doing is, I didn't say this is warning, it's different. I would never say that. I didn't say it yesterday. What it is doing is accepting it because they didn't say, we have an issue with this witness, he's committed perjury. I said they accepted that witnesses committing perjury. That witness committing perjury on that one issue. That's fair comment, Your Honor. It's not inappropriate. It wasn't disparaging counsel. I didn't say Mr. Lewin. I just said they accepted it, and that is true. There's no other way around it.
It is not fair comment. It is completely unethical.
I agree with you.
So, Your Honor,
I agree with you.
What's frightening is Mr. Tacopina just stood up here and basically defended, said, yeah, I said it, but I can say it. He doesn't know or care about the law. That is clear. And, Your Honor, when it's happened 25 times in this trial, with the hiding of evidence, with the late discovery, and with repeated, you told counsel before we started, do not disparage the other side. I said yesterday, you argue what you want about witnesses. You say a witness lied. You do not disparage counsel. You repeated it yesterday. He tried to explain how he didn't make mistakes yesterday, which he did. Now he gets up and he's now admitted, yes, I made that comment. Here's why it's appropriate. Your Honor, it's not appropriate. It's completely unethical. It is immoral, and it's not professional. And again, Your Honor, the fact that he is getting up here saying, yeah, I said it, here's why, just demonstrates again he doesn't know the law or doesn't care.
You're disparaging him right now.
I'm disparaging him because, Your Honor, he's not following the
There is not to be any disparaging of either side.
during argument. The jury's not here. I have every right, obligation, and duty to stand up here and point out that he is being unethical. The first time the court catches me being unethical, Your Honor, the court knows. That'll be the first time. Court knows I don't do that.
Oh,
Court knows. Court's already made.
I've heard enough from both of you. I missed the prosecution accepts their witness committing perjury. I don't think that's fair comment on the evidence. I think that's an improper statement. It infers that the prosecution is allowing perjury to occur. I'm going to sustain your objection, and I'm going to apologize for overruling it, and then move on. If I were the two of you, I would just move on and not make a, bring it to the jury's attention. I would point out, though, I told you at the beginning of arguments that if an objection is made, I'm going to do my best to call it as I see it. You have made 17 objections. I have overruled 12. I have sustained 5. I'm doing the best I can. I will continue to do the best I can, and that's all I can say.
I just want to put on the record that these remarks about being unethical is I've just about had it with him. This from a lawyer who, and I was saying yesterday on it, this from a lawyer who asked the perfect jury for a stipulation that a shooting range was not in California when either he knew it was in California or had no idea that it was in California. Okay? So he literally asked for a stipulation in front of a jury that he knew was not true or didn't know if it was true. And that's unethical. That's unethical. And this is a guy who, the Ninth Circuit just said life to a jury in the Branford case.
Your Honor,
so
Your Honor, Your Honor,
about him
one more thing out of him, and we air everything that's happened in this case, which the court's aware of.
Stop.
He might want to stop.
I'm so correct. Like,
You should be, Joe.
oh,
Let's take a break.
You should be.
Fireworks. And Bob, if I were the judge, I'd be furious. I would do what the judge started with John Lewin. Lower your voice. Do not yell at me. And Lewin can't help himself. This is the prosecutor. He did it again. But my real question for you, Bob, is how do you feel if you're making closing argument and the prosecutor says that you are being unethical and improper in your closing?
Yeah, I mean, Judge, first off, I think you know this from our previous commentary. I cannot stand this guy Lewin. He irritates me beyond comprehension, not just in this case, but in other cases that we've covered. He is such a poor prosecutor. And the fact that that office had to call him to come and assist in this is just amazing to me. He is a bombastic, his commentary is out of control. And here's the thing, as a prosecutor for many years myself, he's letting the defense get under his skin. He is doing exactly what the defense wants. And in this game, I know as a prosecutor, I got to be even keeled. I've got to be it's not an even playing field.
Be the adult.
I have to be the adult because I'm the one who's asking the jury to do a dramatic thing, and basically they know what the consequences of this decision are. Tacopina is doing exactly what he should as a lawyer, and I agree with you. The judge was right in the beginning to spank the prosecutor down, but then kind of capitulated at the end. There was nothing that the defense lawyer said that's unfair comment, that was immoral or unethical. This prosecutor is an unhinged personality. He is a terrible prosecutor, and throwing ethics things around like that is just unbelievable to me. Last point, I've never heard a judge, and you were one, that literally counts the objections and how many times they're sustaining or not sustaining. That was a little odd to me. I don't know if I like that.
And I know we need to take a break, but Bob, I'm going to argue he does it because he knows how these attorneys are, specifically John Lewin. John Lewin, as you know, was in the Durst trial in California. He acted the same way. So this is his personality, and I really struggle with a lack of professionalism in the courtroom.